Welcome to our 5th Women Get on Board speaker series. I don't know about you, but where I am today, the sun is shining bright. So hopefully you're having a bright filled day wherever you are. Cold, but nice and bright. I'm Deborah Rosati. I am founder and CEO of Women Get on Board. Women Get on Board is a member-based company that connects, promotes, and empowers women to corporate boards. And we are pleased to host our speaker series, and the mandate of our speaker series is really to help empower you on your board journey to be more effective in the boardroom. So before we begin, Keisha, can you move to the next slide? We are going to, so welcome. We'll have the presentation by Natalie. I'll do an introduction formally to her. We'll have a Q&A session, and we promise you will be out the door by 1 p.m. So next slide, please. So a few tech tips. Please ensure your camera's off and your mute is on. And we will have Q&A, so please use the chat function at any time to submit your questions. I'll be moderating the questions to our speaker today, and this session will be recorded. And all the slides will be shared in a follow-up email. And also in the follow-up email will be a survey, so we welcome your feedback, and the recording will come to you next week for your reference. So before we begin, I want to thank Stratford Managers Corporation for being our sponsor today on a topic of 20 questions a board member should consider or think about for intellectual property for their companies. In today's world, innovation moves forward at a really rapid pace. And as a key driver in today's metrics, this constant evolution requires proactive care and a keen eye for detail to ensure intellectual property is handled appropriately and managed cost effectively. As a director, you're responsible to ensure that not only the different types of IP are being protected adequately, but the company's funds are spent optimally and the company is managing their IP related risks appropriately. In this webinar, our IP expert, Natalie Giroux, will share some of the questions to regularly put on the agenda of a board meeting to ensure your organization is getting the most from its IP. Natalie is the managing director at Stratford Intellectual Property. She is a pragmatic achiever with extensive experience in the areas of strategic IP. Throughout her career, she has combined deep technical knowledge with business insights and leaderships to serve on a variety of leading edge startup and large companies. She is passionate about thinking and making sure companies of any size continuously innovate and have a strong IP strategy by helping them foster an innovative minded culture and build a cost-efficient IP portfolio combining patents, trademarks, and trade secrets. And Natalie, I see you smiling there. So as you can see, Natalie is very versed in this topic, and just in our pre-meeting, Natalie and I were trying to remember when we first met in our connections through Newbridge. I think it was 1997. So you've come a long way, Natalie. Over to you. Thank you.
Thank you. Let me share my screen. Can you all see my screen?
Yes.
Perfect. Thanks for the introduction. I'm very happy to be here today. As Deborah mentioned, I'm passionate about helping small, medium-sized companies be strategic about their intellectual property. And today I'd like to share with you some topics that you should bring regularly to the board meetings to make sure the companies you're working with are handling IP appropriately. So IP is one of the most valuable assets of any companies, and it applies to all sectors, not just high tech. And as a director, we're responsible to make sure that not only all the different types of IP are being protected adequately, but that the company's funds are spent optimally. So the majority of the question I'll discuss today apply to any companies. So as Deborah mentioned, it's not just about patents here, but also trademarks, trade secrets, know-how and copyrights, which applies to most companies out there, including non-for-profit. So I'll just go through my 20 questions and then we can have a discussion after. So the first aspect is culture. So each company must foster an innovation-minded culture, but also focusing on the respect for intellectual property. So IP should be at top of mind for all employees, and everybody should be knowledgeable in IP enough to avoid unintentional loss of IP before it's effectively protected. So all employees should have some IP awareness sessions, and they should know enough that they understand to be, I call it, have a healthy dose of paranoia about mishandling IP, whether it's the company's IP, but also third party. So are there incentive programs in the company to make sure employees protect IP and keep an awareness of IP? These are good questions to ask on that front. You know, the minute the IP is lost, it's too late, and the company, it's really impossible to recover. So it's really important that all employees understand. So next is processes. So are there processes in the company to make a consistent use of IP? So invention disclosure process, which doesn't mean patents. It could be know-how or trade secrets that are tied to product management, product delivery roadmaps. And here by product, it could mean a really good recipe in a restaurant, not necessarily a product for a high-tech company. Is there an IP governance process in the company to make sure that all the key executives are driving the IP strategy and understanding what's happening with IP in the company? Too often, the IP strategy is handled by one executive in a silo, and the rest of the executive team doesn't even understand what it is. It should be, one person should be accountable, but the entire executive team should know what's happening. Also very important, having consistent patent marking and trademark monitoring processes to ensure that the value of the IP is maximized. Third, very important, employment contracts. So does the company have employment contracts and contractor agreements that includes proper IP assignment clause? Very often I've seen startup companies that have started with two founders that were friends, and they didn't really bother about IP assignment clause. And after a year, one of the founder gets upset, leaves, and all the IP that was created in the first year is lost because the person who left will not sign proper documents for the patent and trademark office and all that. And basically the IP is lost. And that's really unfortunate. So even though you start on good terms, it's always good to make sure that IP assignments and IP clauses are well defined in the contracts. And I'll keep using my restaurant analogy because that also applies to a restaurant. So trade secrets, recipes should be considered trade secrets for restaurants, and copyrights and all that. So that applies across the board. And also, if the company hires a lot of students and postgrad students, it's really important to understand the university's rule about the work that the student is doing at your company during their term, to make sure that you're not actually losing IP when that the university would think belongs to them. So due diligence. So another important aspect is that the IP portfolio should be managed really well, and that everything should be properly organized and kept in catalogs such that it's, we call it, always due diligence ready. You never know when an investor will come into the company and want to see what the IP portfolio looks like. And I was working with a venture capital firm in a previous life, and too often the IP due diligence would delay the funding rounds by months because things were missing, assignments and all that. So it's really important to keep the IP file as one of the most valuable assets, I repeat myself, and present that to investors or potential acquirers in a way that shows that your company is well managed. So IP landscape. So one thing that's really great is that there's a wealth of information out there on existing patents and trademarks. And if the company takes time to search this landscape of information, they can find a lot of intelligence on their industry, on their competitors. So if the company does proactive and regular trademark and patent searching, they will find lots of intelligence on existing and emerging competitors, as well as potential partners. You can keep monitoring your competitors' patents and follow the prosecution in the patent office, which will greatly reduce the risk of future litigation. So yeah, regular patent searching is definitely something that should be done by any company. Next is freedom to operate. So does a company actually has the right to manufacture, sell, or offer for sale their product? So often you will hear investor requesting freedom to operate search, which can be a really expensive search. And often it's done at one point in time, but in effect, it needs to be done 18 months after the first search, because there's patents are hidden, are not public for 18 months. So if you do a search day one, you may think you have proper freedom to operate, but in 18 months, the answer may be very different. So the freedom to operate needs to cover not only innovative aspects of the product, but any of their essential aspects. So for example, if you build a product that embeds an MPEG player to play creative content that you've put together, you have to make sure that the MPEG player you integrate is licensed under the MPEG LA consortium, because then you could be in trouble for including this player in the product. So you also need to have contingency plans, which I'll explain later, in terms of potential licensing that you might have to pay in the future. Filing strategy. This is where
I'm just on a webinar for an hour. So I've had the
does the company have a planned filing strategy to maximize?
Sorry, Natalie. Sherry, can you
It gives
turn
a
your
pretty good idea of what
video?
we're doing
Can
and stuff like
someone
that.
please
So,
turn
yeah,
their
he's
mute
downstairs.
off?
So, okay,
Excuse us,
thanks.
excuse us, can everyone go on mute? We could hear that conversation loud and clear. It was very distracting. So please put yourself on mute. Please, thank you.
Okay, filing strategy. So here we're going to start talking about try to spend money wisely. So does a company have a planned filing strategy to maximize value of the IP while effectively locking in funds? So if the strategy of the company is just to file patents, not even taking into account trade secret or defensive publication, there's a lot of money that can go to waste. Also, a lot of companies file patents in worldwide jurisdictions, but they don't even have a plan or forward-looking budget to actually pay for the upcoming costs. So they spend a lot of money upfront and then prematurely abandon their assets because they can't afford the upcoming costs. So thinking long-term budget is really, really important, and having a strategy that considers target markets, competitors, potential acquirers is really important in a foreign filing strategy. And this also applies to trademarks. Next, does the company often review their IP portfolio to make sure that all the assets are still needed, or is there a way that you can actually divest some of the assets to make money? Or is there opportunities to license some of the assets, again, to raise some funds in a way that's, is not dilutive or anything like that. So licensing revenue can be a great source of financing and does not necessarily involve costly litigation. Some patent brokering firms will work on contingency to find licensees for your patents, and that doesn't mean having to go and litigate or go to court. So the next flip side is has the company considered looking for existing IP that's available for acquisition as a cost-effective source of R&D? So if you have a process to regularly search for patent database on IP that's available for acquisition, for example, from universities or from companies that are just got under or something, there's like lots of IP out there. There's also IP that recently expired that could be used for new R&D or new development or applied to today's technology. So something that expired that was created 20 years ago in the field of ATM that I used to work on can now be used in the field of IP, Internet Protocol, and be very, very effective now that the processor speeds have increased and all that. So growing an IP portfolio from acquisition is a great way to build a sizable defensive portfolio to address any litigation risk that are upcoming. Trade secrets. So I wanted to bring up trade secrets because there's one really valuable type of IP that is often not even considered. So what's being done in the company to protect and manage trade secrets? So, you know, too often company will file patent application while using a trade secret would be a much more effective protection because a trade secret never gets published. The patent in 18 months gets published and is available worldwide, and people that in countries where you didn't have enough funds to protect yourself can use your invention freely and make money on your invention, and you have no recourse. So a lot of software as a service companies can benefit from trade secrets to protect all of what's in the actual cloud. So all of the data management, data processing can be saved as trade secrets. And where you get value from trade secret is by properly cataloging them with just high-level information and metadata such that investors and potential acquirers will be able to assess their value. Coming with trade secret is the need for stringent cybersecurity, of course, to make sure that the trade secrets do not leak or they're not hacked somehow, either on the servers or on your development environment or in between. And of course, you need to monitor on an ongoing basis to make sure no one is misusing the trade secrets or actually stealing them. So, as mentioned earlier, keeping the files and records of your IP portfolio up to date is very important, but also having a comprehensive summary of all company-owned IP that's really up to date and makes a big difference for an investor and a potential acquirer. So you have to make sure that one executive in the company is accountable to keep this information together and up to date, and not having to run after that information at the last minute, because it doesn't really look very good. Question number 12 is valuation. So does the company have a methodology for evaluating the IP as part of financing our M&A transaction? So I've seen a lot of M&A transaction where the company being acquired did not include the IP as an asset for pricing the transaction. And that's really unfortunate, because you can leave behind millions of dollars in the value of your IP. And again, trademarks are extremely valuable, trade secrets, and of course, patents, if that's applicable. So that's really important. And the best thing a company could do is keep a running tab of what they think the value of their IP is. And each time they add a new piece of IP to the portfolio, keep the value add on top of that. So licensing agreements are often used for joint development and with partners and university. And it's really important to make sure that the licensing terms are in favor of the company. Too often, small, medium companies will take on a joint development with university and basically just blindly accept what the university is asking. And too often, they will lose the rights to the IP that's developed in that joint partnership. So it's important to have the clauses that are well defined with what they call background IP, so the IP that's brought into the partnership, And then the foreground IP that's created in the joint development, and be very, very clear about who owns the foreground IP rights. So I would be very careful about signing any kind of licensing agreement without making sure these are well defined and understood. Process and policies. So does the company have a process to protect IP from customers, investors, partners, and visitors? So NDAs, clean desk policies, this doesn't apply these days, but I often do lunch and learn with small companies, and the whiteboards are covered with architecture diagrams and flow charts, and they have like a do not erase in red on it, which drives me crazy, because that means at night, this is open to anyone who's coming, like the janitors and all that, to take pictures and put that on the internet, and your IP is then given to the public without any kind of protection. So clean desk, whiteboards are wiped after the meetings. That's really important. Making sure NDAs agreements are consistently used, cataloged, and re-signed after expiration period. So have someone who's managing the NDAs is really, really important. So you want to really make sure that you have all these safeguards there. And most importantly, if you're using trade secret as a type of IP protection. So infringement. So what does the company do to monitor for IP infringement? So here we're talking again, trademarks, copyrights, patents, and trade secrets. So the USPTO or CIPO is not going to monitor for the company. It's the IP holder that has the burden to identify and deal with potential infringement. So you need a recurring process to see what your competitors are doing. Do they have emerging products that might be infringing? So inside the company, there needs to be a process to keep on top of that. And if an infringement is identified, what actions are being taken. Doesn't, again, mean to go into costly litigation, could mean just sending a letter of intent. But you want to be able to notify a potential infringer as soon as you can, because you want to be able to recuperate as much damage as possible if needed. So IP risks. Does the company have a plan on how to handle IP risks? For example, if the company is adhering to industry standards, you have to check if the IP bylaws relating to these standards are being taken into account. One of the reasons I'm doing this today is because Newbridge Networks was sued for compliance to industry standards. At that time was IETF, ITU, and ATM Forum. We were just building ATM switches that were compliant to these standards and ended up getting sued. And the lawsuit lasted 5 years and was really damaging for Newbridge. And this is why I'm on a mission to prevent other companies to go through this. One of the biggest mistakes was that we did not have IP indemnification clause in our purchase agreements. So we were putting together a product that had pieces from left and right, chips that we were buying from third parties, but we never put any clauses in our contract that said, should there be an infringement on this chip, the company who's selling us the chip will be liable for dealing with this lawsuit. That was a huge mistake we did. So that's something that's really important. I mentioned MPEG-LA earlier, so that's even applies to including embedding an MPEG player in a product. That MPEG player must be licensed under this MPEG-LA consortium, because there's a lot of industry patent pools like MPEG-LA that basically they put together all the patents that they deem are standard essential, and then they will go and go after you to pay for a lot of license fees if you didn't buy a component that's already licensed. And the other thing about risks is non-practicing entities, and you may have heard in the past the term patent trolls. So there's a lot of companies that buy large portfolios of patents, they don't build anything. They just own patents, and then they go sue companies for damages, and that's how they make money. Wyland is an example, and there's lots of others. The problem here is that there's nothing you can countersue with, so it's very difficult to deal with. Fortunately, the US has been more difficult on these companies, so it's not as easy to win lawsuits with non-practicing entities. So it's really important that every company understands the IP risks and they take proactive actions. Like I mentioned earlier, keeping provisions in the finance for potential licenses, or adding contingency plans if you have to change a component that is not licensed with another component that's licensed. That may cost more, but just having contingency plans is really important. Okay, so open source software, that's another tricky one. How does the company track the use of open source software? So open source seems to be all the software you can get, you think, for free, but each of these open source software communities have copyright licenses that must be adhered to. So it's really important that you understand what pieces of open source is being used in the products or in the service you offer, and that you keep a track of it and keep track of how you're adhering to the license requirements for these pieces of open source software like GPL or Ubuntu and all that. There's a long list of them. So you also need a process to monitor how you're using the open source in your products and understand the different license agreements. So that's a lot of work, but it's really important because I was involved in a couple of M&A transactions where the acquirer did a scan of the software and found a whole bunch of open source software and basically decided to hold off on the deal until the company had removed all the open source software that was there. And that was Siemens acquiring a small company that SkyPoint had invested in. It took them like over 6 months to do that. And basically the whole deal was on hold until that was properly done to their satisfaction. So open source can be a real can of worms, and you want to be really careful about that. The next is litigation. So does the company have a plan in case they get sued for IP infringement? And trust me, one of my clients recently got sued, and it's really important to have a plan ahead of time, because the minute you get sued, the first thing that happens is there's a lot of emotion involved, and the temptation to do jerk reaction is really high. So even with the best IP strategy, it's possible that the company will get served with a lawsuit. Regardless whether they have a solid ground or not, they might just do it as a nuisance factor for you. So in the case of my client, they just hit the top Gartner report and went above their competitor, and the competitor got upset and just launched a lawsuit. So that's really unfortunate, but you have to deal with it at this point. So having a plan, like a response team who's going to be involved, what are the internal and external communication plans, because you want to make sure that internally employees don't start to comment on the lawsuit and create all sorts of discoverable material that will be damaging in the future. And somehow you have to be able to, the company has to be able to deal with the emotional side pretty quick and then move on and execute the plan. You also want the company to deal with this lawsuit without disrupting its day-to-day operation, because that's actually the goal of the competitor suing you, is to disrupt you and your progress and the company's progress. So, okay. Next question is security. I mentioned cybersecurity earlier, and that's really important. Like I said, if trade secrets are part of the IP strategy, cybersecurity is paramount. But even if patents are a solution for IP protection, until the patent is filed, everything must be kept secret. Otherwise, you may lose everything. So the security must be on every computer. Everybody's, all the employees must have secure Wi-Fi today that we're all working from home, or there has to be ways where the work and the exchange over the networks are very, very secure, because it's easy to spoof, the traffic coming out of a house. So the key here is to make sure the IP doesn't leak before it's properly protected. So you want to have someone that knows cybersecurity and keeps at the top of, state-of-the-art systems to make sure you can also track who's been accessing your systems and all that. So, and in the work from home as well, but making sure that papers are properly shredded and nothing is just put in the garbage without being careful. So the last is budget. So how is the company planning to spend its money on intellectual property, and how is it tracked? So as I said earlier, a lot of companies will invest in parallel patent filings. Instead of doing one umbrella filing, they'll go into what's called a patent cooperation treaty, thinking that in the long term they want to do foreign filings, but they don't budget ahead of time for the next 2, 3, 4 years. So a lot of law firms will not be proactive giving advice on long-term budget, but I've seen so many companies abandon IP assets because they didn't plan enough money going forward. And it's really, really sad, because those are really valuable assets. So you don't want to waste your funds by spending a lot of money at the beginning and having to abandon. So that was my last question. And all this was what's something that's interesting that happened just before Christmas is the ISO, International Standard Organization, issued a standard on IP strategy and management. And the 20 questions I just described today cover, 99% of this standard. And this, again, applies to all the companies. So it's not just something I made up, these questions. Actually, it's being vetted by this international standard. And I hope all the companies you work with in the future at least understand enough about IP to not fall into some of the traps I mentioned. And after the webinar, we're offering another document that's myths and mistakes that are commonly done about IP, and it covers some of this and a bit more. So that's.
So thank you, Natalie. That was wonderful. To get through 20 slides in such an efficient manner. I love it. And you've got, it was very well prepared and thought through. So we've got some questions that I'll, share with you. And I'm sure for others, if you haven't put any questions in the chat function, I know Natalie will be very happy to hear the questions that you have. So we'll start with the first question, Natalie. The first question up is, what is the best way to prevent action from patent trolls, usually US-based, who attempt to patent everyday processes used in many businesses traditionally? I know you touched on it. I think the question came before you spoke about it, but anything that you would like to, any measures, any steps that companies should take to prevent these patent trolls?
Well, unfortunately, there's not much we can do about patent trolls. As I said, one of the good things is there's been US litigation against them. So the non-practicing entities don't have it as easy now if they go after you. But if they do come after you, the key here is to take care about how you respond and make sure that they have solid grounds. I've seen a lot of NPs coming in with just a letter saying you infringe, give us $100,000, and it's usually quite easy to convince them to go away these days. But there's not much you can do against them because they think they own the IP on everything. It's just how you respond to it is the key. And again, emotion is always the first reaction, and this is where you need to step back and say, okay, like these people may not have rights here, and
you've mentioned that a few times on the emotional element. So a lot of times to have process in place before you hit that, emotional, because, you know, these, for some people, this is their life work, right? And how do you protect it? So we have another question for you, Natalie. Filing strategy. Given the high cost of filing for patents, trademarks, what strategies should we consider to protect Canadian assets, trademarks, trade secrets from being manufactured ex-Canada and then imported back into Canada?
So depending on your funds, a US patent is always, or a trademark is always covers the biggest market. So technically, if you have a protection in the US, companies may not bother copying you if they don't have access to that market. So if your funds are limited. Otherwise, going through like covering Europe and some Asian countries might help give you broader coverage. But typically, if the US is covered, people won't come on your turf.
Excellent. In a perfect world, if you're protected. Another question for you: how do you enforce your rights as a holder of trade secrets?
So good question. And there's a lot of new law coming where if you can prove that someone actually stole your secrets, or an ex-employee left and suddenly went to a competitor and the competitor has now the same capability as you, you can actually show that they've stole the secret. The key is to keep a catalog of all the trade secrets you own. Not just say, oh yeah, my product has trade secret. No, I have a trade secret on the database mining this, and just high level keywords. But then you list all the employees that have been working on this piece of software. And when the employee leave, you put them on notice to say, you worked on trade secret ABC and we'll be watching you going forward. So you can work on other things, but make sure that you're not doing the same thing as you've done here. So
it seems to me that could be quite manual. Are there good software that can track that development?
We have a software. In the last few years, I built one because it didn't exist. But even if you just used an Excel spreadsheet and kept metadata, and I have a screenshot of our system with all the information that you need to keep. But that's really important.
Okay, thank you. Next question. How do you ensure IP oversight with unknown future output? For example, the IP created through AI. Yeah, do you want me to repeat that?
Yes, I think.
Yeah, same here. So how do you ensure IP oversight with the unknown future output? For example, the IP created through AI.
Okay, so if I understand, we have AI, so working in the cloud, that's like processing data and generating new data. And this would be part of what I would call the trade secret piece. The key with trade secret is that it can't be reverse engineered. So, and I should have mentioned that before. So if your AI is in the cloud and all you're doing is sending data from your phone or from a sensor to the cloud, and the cloud comes back with an answer, the protection of the AI algorithms, the data it generates, can all be trade secret, because the only way someone would access this code is by hacking the server or doing something illegal. On the other hand, if the AI algorithms actually in the software on my phone, I can take my phone to Tech Insight or Chipworks here in Ottawa. We are the experts at reverse engineering in the world. They will take apart the software to the last bit and reverse engineer all the details of the software. They can do hardware down to the little piece of wire, right? So it all depends whether the AI algorithm can be reverse engineered or not in a legal manner. Because it's not illegal to go to Tech Insight to reverse engineer something, if you acquired the thing that you're reverse engineering in a legal manner. So,
okay, thank you.
Hopefully I answered the question now.
Yeah, well, you know what? I would say that for anyone, you know, I'm sure Natalie would be pleased for you to link in with her on LinkedIn. So if that wasn't fully answered, I'm sure Natalie could further give background on that. So next question, because we've got a few more. Can you give examples of best-in-class examples from IP portfolio companies that, you know, would be best in class? And I mean, you've seen, you know, the best, and you've seen, you know, used examples of what not to do. But are there some, and hopefully through your advisory work and working with emerging and innovative companies, you know, you are creating best in class, but do you have some companies that you could shine a light on?
Yeah, of course I could list all our clients.
Of course.
But, you know, we worked with companies like here in Ottawa, Kinaxis, and there's a company in Waterloo called, sorry, my dog is barking, Ignis Innovation, which they grew, all they do is create patents, and they license patents, and they license their portfolio of patents to LG for a lot of money. Another one of my first client, which was a SkyPoint company, I worked with the CEO at the beginning, and I was like, okay, let's put together like a small patent portfolio. And we're thinking long term. And I was like, don't think about just the software you're building now, but what would you build that's going to be useful in 5 or 6 years? And what if, you know, you didn't have limitation with processors and all that? And the CEO is quite creative, and we patented the App Store in early 2000, and we sold the patent to Apple and that saved them a funding round. So that's a good example of a company that use patents and use proactive thinking in their way they file patents, and we're successful about it. So.
That's a great example. Thank you. Do companies need to prove compliance with the new ISO standard, or is it simply a guideline?
It's a guideline, but there's a lot of things in there that will help companies save money and develop better process to better handle their IP. So I was quite pleased to see that, because it's really in line with everything I talked today. It's being careful, being proactive, and pragmatic. So yeah.
The P's. Awesome. So next question is, and also I'm coming up to the last question. So if anyone hasn't typed in a question, we'd love to hear from you. Are there benchmarks for budgeting your IP strategy?
No, yes, we have like a tool that's available. It's an IP coster if you want. So you can say, here I have a patent I want to file in these countries, and it's going to give you the price for, you know, the next 2 years at the different time slots where you need the money. But then there's like, you have to estimate when the office action will come in, because one of the most expensive piece of prosecution is the patent prosecution. So for patents, it's what we call office actions, where the examiners come back and say, well, we don't think this is patentable. You go back, and you can go back and forth 2, 3, 5 times. And that's really expensive depending on the law firm you work with. And this is where people don't budget enough money. And there's not really a way to predict how it's going to happen and how many times you're going to have back and forth. So yeah, it requires a bit of kind of creative thinking for the front. But we've developed a machine learning system in our tool that actually is starting to learn how many office actions, depending on the art unit and the type of patent. So eventually this will come, I'm sure, will be a commercial tool to do that.
So let me ask you a question. Do you have a patent on your tools?
Not on this tool, no. We use it internally, so we keep it.
Okay, it's an internal tool. We've got a few more questions coming in. So next question is, are there any unique considerations when apps are built in a no-code, let me get this, in a no-code, low-code model?
No code. So I've never heard that term, so I'm really sorry. All I would say is if it includes open source software, or if you're embedding pieces of other people's code, I'd definitely be very careful about underlying license requirements and meeting these licenses. So if you're building an app that has all the pre-made pieces and you're adding to that and combining, you have to make sure those pieces have proper IP licenses, or you make sure you embed these pieces with proper indemnification clauses and purchase agreements.
Thank you. Next question is, where does IP governance accountability generally fall in a company? Is it tech, is it legal, or does it vary?
It varies. Most often, it's with the CTO that I've seen companies. The CTO is accountable for IP. And that's a little bit unfortunate because the CTO has so many other things to do, very little IP knowledge, and they often resort to being very reactive, just handling it on a as needed basis where a lot of money can be wasted. And it's more of an afterthought than an actual strategy. So when a company has a general counsel, sometimes it's handled there as well, but the GC is often too separate from the actual product development. So then there's a gap there. So it has to be, that's why designing a strategy is better, because then you can understand all the stakeholders.
That was a question I was thinking of, who typically owns it within a company, but it varies. I guess it really, the important thing is to have the strategy first, and then everybody adheres or is accountable under that strategy. Yeah. There's no more questions that have come in. I guess what I would love to hear from you, Natalie, if I may, I'd love to, I know that you're passionate about this, and, you know, at Stratford Group, you do workshops. I'd love for you to do a little plug on the type of work that you have, because if anyone is interested in follow-ons or anything, and I know we have materials following on, but just because we have a few minutes, you know, you're so passionate about the work you do for others, if they are interested in getting more of an in-depth, what type of, I know you've got workshops and other programs.
Yes, so why I'm so passionate is because at Newbridge, we got sued. I mentioned it earlier. And I spent 5 years of my life trying to defend ourselves against this lawsuit. And it was really, I took it very personally, and you know, I understand all the emotions involved and all that. So after my time at Newbridge, I decided to help small and medium companies try to design an IP strategy and design IP awareness to avoid all the mistakes Newbridge had been in the early days. And that's what I've started implementing over the last 25 years. And that's what's driven all these aspects. Like you see, it goes beyond having just a couple of patents and saying, oh, I have IP, I'm good, I don't need any. No, it goes, the awareness part, like you should have seen the stuff that Newbridge people had written in their lab books and how damaging that was during the lawsuit in front of a jury. So, you know, just these things about when you write something about IP, you have to always think that this could be disclosed to a jury. They're simple, you know, or like I said, the whiteboards that are full of you know, flow charts and all that. People are giving their IP away where it's their bread and butter. So yeah, I became over the years very passionate about it, and that's what we do full time. When the pandemic started, we designed an IP strategy academy, which everybody has access, which has very short videos covering a lot of these topics. So if you want a bit more detail on all that, they're like 5-7 minute videos, very graphic and fun, that explain some of the basics of the IP. So. And then our service that we offer is to address what you were saying. So we're offering virtual IP management, where we take on the proactive management of the IP strategy for the CEO, the CFO, or the CTO, who's been tasked to be accountable for it. And we do it for him or her as needed. So.
That's awesome. We did have another question that came in. As a board member, is it reasonable to request the company have an IP strategy? It seems like it would be worthwhile. I mean, part of this series were questions to ask as a board member. So do you want to comment, or what have you seen in play?
Definitely. I mean, these are the detailed questions you can ask, but the first question you can ask is, what is your IP strategy? And if the answer is, we have a couple of patents or we have a trademark, then it'd be worth digging a bit more. And I gave you the example of a restaurant. The restaurant recipes are the differentiator for the restaurant. So how is the restaurant protecting its IP through contracts so that the cooks don't go and open another restaurant and do the same soup? You know, like so it applies to everything.
Excellent. Well, you know what? I think that in essence of time, those are the questions that have come up. And, thank you for, your generous time and your passion. It shines through. I just want to thank everyone for joining us today. And thank you, Natalie, for sharing your insights on IP and IP strategies and IP portfolios. It was phenomenal. It's a topic that I hope that all of us might be able to go to your IP Academy and take some more learnings. Also wanted to thank Stratford Managers Corporation for being our sponsor today. And right after the session, you'll get a follow-up with a thank you, a survey. We welcome your feedback. It'll have the slides from today. It will have some thought leadership pieces that Natalie and her team have developed. And then next week, you'll get a recording of the session. So just as a note, our next Women Get on Board speaker series is scheduled for April 13th. Are you ready for public service boards? And I just want to end on a note to say, wishing you all a very happy Lunar New Year. Wishing you a year of the ox, which is filled with health, happiness, and prosperity. Have a great day, and thank you for joining us.
Thanks for having me.
Thanks, Natalie.
Bye.